This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about why a chief executive officer of a corporation used money from his company and its insurers to defend against criminal charges brought against him for fraud by the United States government, and why his conviction of wire fraud required the defendant to repay funds advanced by his employer and their insurers because he was convicted of wire fraud and therefore could not have been acting in good faith for his corporation. Defendant Dr. W. Scott Harkonen was the chief executive officer of InterMune, Inc. Following the issuance of a misleading press release in 2002, Dr. Harkonen became a criminal defendant. To fund his sophisticated and well-resourced defense, Dr. Harkonen requested and accepted various sizable advancements from the company that funded the advancements via several directors' and officers' insurance policies and from its own coffers. The advanced sums were subject to repayment if the litigation was found to be non-indemnifiable. A federal jury subsequently convicted Dr. Harkonen of felony wire fraud in 2009. Dr. Harkonen then embarked on nearly a decade of unsuccessful appeals to overturn the conviction. In InterMune, Inc. versus W. Scott Harkonen, a decision of the Court of Chancery of Delaware on August 1, 2024, the court resolved multiple motions that were brought by Dr. Harkonen and InterMune. In light of the wire fraud conviction, two of the company's excess D&O insurance providers demanded that InterMune and Dr. Harkonen repay the sums advanced to Dr. Harkonen to litigate the wire fraud charge. In 2019, InterMune and Dr. Harkonen settled with the two insurers, while InterMune paid the settlements in full and retained the right to sue Dr. Harkonen for recovery. InterMune exercised that right, with the litigation presently pending in the Chancery Court. On March 22, 2000, the company and Dr. Harkonen entered into an indemnity agreement, whereby the company agreed to hold harmless and indemnify Dr. Harkonen to the fullest extent authorized or permitted by the provisions of the bylaws and by Delaware law. Dr. Harkonen executed an agreement to repay the amounts incurred in his defense if it shall be determined ultimately that he is not entitled to be indemnified under the provisions of the agreement, the bylaws, or Delaware law. On March 18, 2008, a grand jury indicted Dr. Harkonen for fraudulently promoting a drug, Actimune, an interferon gamma 1b drug, by putting out false and misleading information about the drug's effectiveness in treating IPF. Dr. Harkonen was indicted on one count of felony misbranding and one count of felony wire fraud. The cost of litigating Dr. Harkonen's charges with a large and prestigious legal team defending him was substantial and depleted the burning limits of the D&O policies. On September 29, 2009, regardless of the efforts of his high-priced lawyers, following a 6-week trial and 4 days of jury deliberation, the jury acquitted Dr. Harkonen of misbranding, but found him guilty of felony wire fraud. On December 13, 2011, the company and Dr. Harkonen entered into a settlement agreement to address the company's obligation to advance Dr. Harkonen's legal expenses, and in the 2011 settlement agreement, the company agreed to pay almost $2 million of Dr. Harkonen's outstanding legal expenses. On May 16, 2011, Dr. Harkonen unsuccessfully appealed his wire fraud conviction to the U.S. Court of Appeals for the Ninth Circuit. He also tried to get the U.S. Supreme Court to hear his case, but they refused. Dr. Harkonen's wire fraud conviction also had professional ramifications, and Dr. Harkonen, who was investigated by the state of California and was charged to lose his license unless he fulfilled some of the terms of the disciplinary action. And because he refused or failed to fulfill those terms, he remains no longer licensed, and his license to practice medicine in California has been canceled. This court, in this case, now in 2024, granted partial summary judgment in favor of the company, holding that although he received a presidential pardon from President Biden, the pardon did not render Dr. Harkonen's wire fraud litigation successful on the merits or otherwise for purposes of indemnification under Delaware law. Dr. Harkonen had a full and fair opportunity to challenge the conviction through the appellate process, and that did not succeed. So the conviction stood, he just didn't have to hold it in his record because of the pardon. The corporation, rather than the employee, bears the burden of proof in an advancement clawback action like that before the Delaware court. The bylaws provided that the corporation shall indemnify its directors and officers to the fullest extent not prohibited by Delaware law or any other applicable law. Dr. Harkonen is precluded from establishing good faith in his receipt of legal fees paid by his corporation because his wire fraud conviction is conclusive evidence that he acted in bad faith. Dr. Harkonen was convicted of felony wire fraud, and accordingly Dr. Harkonen was found to have acted in bad faith. Dr. Harkonen, in this case, therefore, must repay the company the $5,906,927.02 it seeks in the action as repayment of advance sums for which Dr. Harkonen is not entitled to indemnification. Dr. Harkonen voluntarily demanded their payment and gave an undertaking to repay, and Dr. Harkonen is therefore ultimately responsible for those legal expenses incurred in litigating his wire fraud convictions. In my opinion, this case is an example of an abuse of a corporation's obligation to pay to defend its CEO. The corporation and its insurers paid almost $6 million to defend Dr. Harkonen to claims of wire fraud, to even obtain money from the corporation for the expenses in seeking a presidential pardon. His guilt did not go away with the pardon. In fact, he had to admit to the guilt to be eligible for a pardon, and he must now repay the corporation $6 million plus interest. Dr. Harkonen was a criminal who took advantage of the bylaws of the corporation, the directors and officers' insurance policies, and every court with whom he was involved over a period of almost 20 years. And so I expect him to appeal this ruling as well, as he continues an effort to abuse the corporation he led and the law.